Let's continue our discussion about the courts and the courtroom process. Today we're going to dive into what's called jurisdiction, which is really the authority to hear a court case, either because a court case might be about a specific subject or because the court case might be in a specific area. For example, we talked about jurisdiction when we talked about police. Police have a jurisdiction that they're in charge of. For example, the municipal police are in charge of that city. The sheriff's department is in charge of that county. The FBI has the entire United States to be in charge of. So different police forces have different jurisdiction, and so do courtrooms. Some courtrooms only handle a certain subject. Some courtrooms only handle a certain area. And that's important to realize as we dive into different types of courts. For example, there is geographic jurisdiction, and this means it focuses in on an area. For example, there are federal versus state courts. There are state courts in the state of Wisconsin, and there are federal courts across the entire U.S. that handle federal issues, and there are, they're inside states too. So they handle different jurisdictions and different laws too. If you go back to our criminal law unit, we talked about how there's different types of law, different types of statutes. There's different constitutions for that matter. There's federal and state constitutions. And the federal and state courts have to handle different things then. There's also different state courts. What might be a crime in Wisconsin might not be a crime in Minnesota, and vice versa. That means you have to have different courts in different places. Now, I often get asked the question, what happens if you commit a crime in multiple states? Well, those states would negotiate for who gets to have the trial first and who potentially gets to, you know, hold you in a correction facility if you are found guilty. Oftentimes they go with the state that has the most evidence against you or has the most criminal charges against you first. They're trying to get a bigger case done before the smaller cases might be easier to get those ones done as well. And that means you could have multiple court cases. If somebody goes on a crime spree across multiple states, that could create a lot of court cases. And lastly, there could be international issues. What happens in the United States can result in a trial, but can you be charged with a crime for something you did outside of the U.S.? Potentially. There are certain things that we charge people with criminal activity even though they're not on U.S. soil, despite the fact that we typically don't. You wouldn't think that would be happening. If you commit a crime in Wisconsin and you're over in Minnesota, they're not going to charge you for that crime in Minnesota. But international law can be a little different. You commit some sort of crimes in Australia, they might charge you with that crime even in the United States. Now, there are different types of courts as far as procedure, too. There are courts that handle nothing but trials, and there are courts that handle nothing but appeals. And I'm going to explain what both of those are in a moment. The trial court is kind of what you imagine when you think of a courtroom. When you see courts on TV and movies, it is a trial court. There are lawyers on each side, like this image. There are witnesses that go up to the stand and answer questions. There's evidence. There's objections. Think of the OJ trial. That is a trial court. There's an actual trial proceeding going on. There's even a jury in a trial court. That's going to be an important part. And they have what's called original jurisdiction. They're the first ones to hear the case. In OJ's court case, he had one trial, and it was in trial court. There was not an appeal. So that trial court focuses on, are they guilty of the crime? And they're going to have a jury decide that. Meanwhile, if you're unhappy with your trial court decision, let's say you go to trial and you lose, and you feel like you've been wronged, you can take that up to a higher court called the Appellate court or the Appeals court. And the Appeals court doesn't have a jury. It just has judges. That's right, not just one judge. 3 judges or more are typically in an appeals court. You want to keep it an odd number, though, because you don't want to have ties in any appeal court. And what happens is your lawyer goes in front of the appeals court, makes its case, and then the other lawyer goes in front of the appeals court and makes its case. You're making your case about why the previous court, the previous trial, that trial court, should be overturned, why it should be reversed. So you're trying to get the previous decision undone and basically put into the other direction. And this is a difficult process. You don't have any jury. You don't have any evidence. You don't question any witnesses. It is just your lawyers basically arguing that the last case was wrong. Now let's dive into different types of courts that we have in the U.S. For example, there are state courts, and there are state courts that we have that have very limited jurisdiction. For example, there are local municipal courts that are sometimes called magistrate courts, and they tend to handle minor disputes. They issue warrants for the police pretty much any time of the day, and they handle kind of the typical crimes you would see in a city or a county. Our municipal court is, of course, in Wisconsin Rapids, where they would handle any major disputes. Now, there are what's called specialty courts in the state of Wisconsin. And these specialty courts focus in on a very specific type of law. For example, we have a drug court in this county as well, and that court handles nothing but drug violations. Now, this allows them to be very narrowly focused in. This allows the judges to be very narrowly focused in. And what can happen is they become more efficient. So they become more, they function well when it comes to that bureaucratic function. You start seeing them come up with proper rehabilitation ideas. So they kind of get an idea of, hey, we've had this criminal before, they haven't been rehabilitated in this way, let's try something else. So they start learning what is kind of best to handle these different drug violations in these drug courts. And it also speeds up the efficiency and rehabilitation of the suspects. So these problem-solving courts are able to essentially focus in on a big problem area. And drug courts aren't the only ones that exist, but they're pretty prevalent, as you can see, across the United States. There are other trial courts or other limited jurisdiction courts besides drug courts. There's courts dealing with nothing but guns. There's courts dealing with just juvenile offenders. There's courts for domestic disputes like divorce. And there's even courts dealing with just elder abuse. Now, aside from that, we do have a structure very similar to the United States in our state. We have those local courts, those municipal courts, those drug courts and whatnot. But you can appeal your decision to a higher court, to a court of appeals. So if you're unhappy, you can appeal your decision at the state level to a different level. And then we also have a state Supreme Court. In Wisconsin, our state Supreme Court is elected, so those judges serve for a 10-year period. They're elected. They serve in Madison, and they would be the final decider of a court case dealing with Wisconsin law, unless you appeal from that Supreme Court to the U.S. Supreme Court, which is absolutely possible. Now let's look at the federal system, which you may be more familiar with, and it's got a very similar structure to Wisconsin. There are district courts, which are the trial courts. So we have two trial courts in the state of Wisconsin. One's located in Madison and one's located in Milwaukee. You can see our state is divided into two different districts. And this court is handling the original trial. So there's juries, there is witnesses, there is lawyers, there's a judge, and you're basically making your case about a federal law. It might be something like bankruptcy case. It might be something like some sort of federal violation like texting while driving or an act of terror or something like that. That type of case starts off in just a district court, a trial court. Then it moves up into what's called the circuit court. And there are 13 different circuit courts across the United States, and they deal with a region. The circuit court is essentially the court of appeals. And what happens is you go before three judges and they decide your case. They decide your appeal. So once again, this is not a trial, it is an appeal. And that's important to know the difference between those two. And lastly, if you're unhappy with that decision as well, you can take it up to the Supreme Court of the United States, also known as SCOTUS, which is the highest court in the United States. Their decisions are not able to be appealed. So if they decide that you were wrong and you shall face your punishment, then too bad. They have the final decision. The catch is they very rarely hear a criminal case. If they hear a criminal case, it's really going to have to do with a constitutional issue. And I'll give you an example. Just a couple years ago, there was a case called Carpenter versus United States. It was a criminal case. A man was charged with being a bank robber. There were a bunch of bank robberies in Michigan, I believe, and they caught one of the suspects. Now, they used that suspect's phone number to identify other phones that have been near that phone very often. And they found that the person that they were going to accuse of the crime, Carpenter, had a cell phone pinging at that same location. That cell phone was near the banks at the time of the robbery, that cell phone was around the other suspect at the time. And they brought this individual in for charges. And Carpenter argued that that was an illegal search, that they searched his phone without any probable cause. And he ends up winning. But this isn't a case about whether or not he was innocent or guilty, really. This was a case about a constitutional issue, about his rights being violated. So that's the type of case that goes to the Supreme Court. Constitutional cases. Think like Brown v. Board or Roe v. Wade or Plessy versus Ferguson. We're talking about big constitutional issues. These are pretty much all appeals, and the cases are themselves chosen by the judges. The judges choose to reject a lot of cases. They get offered thousands of cases a year, like 6,000 cases, and they turn down almost all of them. They hear about 80 to 100 cases a year. That's not many cases. So it's more than likely that your cases are going to be solved here if you're appealing them. So they're not going to go any further than the U.S. Court of Appeals. But the rare few do go forward. It's going to need 4 of the judges on the Supreme Court to want to hear your case. So you're going to have to convince a few of them that your plea should be heard. Now, lastly, when your Supreme Court case is heard, you have about 30 minutes to argue your case, and then you have to wait a while. You might have to wait months. We just had a court case that finished up their hearing in November, and they came out with a decision in late June. You might have to wait a long time to figure out the result. But the result is given in what's called the majority opinion. The majority of the Supreme Court, backed up this idea, and that's the decision of the court. But the Supreme Court very rarely all agrees. So sometimes you have concurring opinions, and these are people on the court that agree with the majority opinion, but for different reasons. And then you also have dissenting opinions, or opinions that disagree with the majority opinion. And that happens very often as well. These 9 Supreme Court justices are kind of experts in legal fields, but also can disagree with each other. And that's important to realize too, that the Supreme Court's not always final, and it doesn't always, turn out the way you want it, and there could be different disagreements going on in that Supreme Court as well. Now, let me know if you have any questions, and I'll be able to help you out with that as well. One more thing I forgot to mention. The Supreme Court does establish then precedent. If you recall back a couple units, we talked about precedent, that the Supreme Court can establish essentially case law. They're essentially creating law when they make decisions that have to be followed by other courts. Okay, that is enough for this video. Stay tuned for the next one on the court process.